May it please the court, Jerry Laughlin of the Greene County Bar together with Lanny Norris of the Carter County Bar, and we have the privilege of representing Amy Tochev, the trustee of the Amy Tochev Life Trust, the owner of the property at 1501 East Stone Drive in Kingsport, Tennessee, that was sold at a delinquent property tax sale on December 16, 2020. I'd like to reserve 8 minutes for reply.
Council, we pretty much limit it to no more than 5 minutes on that. Otherwise, it kind of flips who's doing what.
5 minutes then.
That'll be fine.
Thank you. What we have here is a situation where in April 1, 2018, a delinquent tax suit in Sullivan County was filed naming Ms. Tochev as one of the defendants, and 2 summonses were issued to her because the property consists of 2 tracts. In April 1, 2018, there was a similar suit filed for 2017 delinquent property taxes. 2 summonses were issued to her again. On April 1, 2020, a suit was filed for 2018 delinquent taxes only in the body of the complaint. 2 summonses were issued to her. And on April 2nd, 2020, the cases were consolidated at the request of the delinquent tax attorney. There is no dispute that the fact that none of these summonses were ever personally served on Ms. Tochev. She, unfortunately, learned that a default judgment had been entered against her on October 16, 2020, and an order of sale went down, and the property was sold on December 16, 2020. She learned in a letter from a representative of the purchaser on March 23, 2022, that the property had been sold for $174,000, and this is property that's tax appraisal of a little over $800,000. Needless to say, she promptly procured counsel and filed a Rule 60.02 motion to have that tax sale set aside. Numerous reasons are set forth in her motion, and numerous reasons are set forth in this appeal. But given the limited time that I have to address the court this morning, I would like to focus on just a portion of what we raised on the appeal. What I would like the court to focus on is what did the record look like as to service of process at the time of the entry of the default judgment on October 16, 2020, in each of those 3 cases. Now, in the 2016 delinquent tax case, the record is undisputed. There was a return of service and by certified mail stating that under the return receipt that it had been accepted by a Georgia Counts. Ms. Counts testified at the hearing in this matter. What is noticeably missing, however, is any affidavit. There is absolutely no affidavit for either of the summonses issued in the 2016 case, as is required by Rule 4.03. Now, in the case last year by the Court of Appeals in Simmons versus Strickland, it was found that that was a fatal defect, the lack of any affidavit for service of process. And the default judgment was set aside in that case. In the 2017 case, at the time of the entry of that default judgment, the summonses did not reflect any return receipt for a certified mailing. In that file, there is no return receipt whatsoever for the summonses that, any summonses that were, and there's no other return of service except there are affidavits in the 2017 case file. Now, those affidavits accompanying the summons in the 2017 case have a caption that refers to the 2018 delinquent tax case. But they're found only in the court file for the 2017 case. There is nothing as to evidence of service of process in the 2017 case. In the 2018 case, what we find are 2 return receipts. The signature line contains what we characterize as illegible markings. To this date, no one has been identified who would have signed those cards, those return receipts. In the 2018 file, there is no affidavit or other return of service. None whatsoever. Just those 2 green cards with the illegible signatures on them. Now, what the county wants you to do is to say, well, why don't we consider those affidavits in the 2017 file as if they were in the 2018 file? If you were to do that, I have to point out that the affidavits in the 2017 file that they want you to consider as a part of the 2018 file don't have all the information required by Rule 4.03. There are 2 things that Rule 4.03 says you've got to have in that affidavit. The day you mailed it out, the certified mailing, and the date the certified mail receipt was returned to you. It doesn't have that date. In other words, only 50% of the information required by Rule 4.03 is in either of those affidavits in the 2017 file that they say goes with the 2018 case. We submit that that affidavit containing only 50% of the information required is itself deficient, even if you were to consider it in the 2018 case. Now, if you look back at Rule 4.01(2), which says that the process server name and address has to be on the return of service, which is what the affidavit is, the address of the process server is not on there.
I'm sorry for interrupting, but all of those arguments relate to the attempt at personal service, and they're arguing that they served her by mail, and so no return receipt was required when they served her by mail.
But it is when we follow Rule 4.03, I believe, and it says by certified mail. And that's what they tried to do, and there's always that return receipt that has to be filed with the court. And they say that they tried to comply with Rule 4.03, which is the certified mailing. That's what they say they tried to do.
If they sent the mail to the address that the taxpayer had listed as being the taxpayer's home address, what more was required of them?
That they comply with the provisions of Rule 4.03, which would require the certified mailing. That's what that's what they claim in all their pleadings, is that they attempted to comply with 4.03, and that's what they rely upon, and those are the requirements. And of course, what this court said back in Bradley County versus #Inc., I believe it is, And it reiterated what the Tennessee Supreme Court had said back in the estate of McFerrin versus Infinity Transport, which is that Rule 4.03 has certain mandatory requirements for documenting service of process. And as the court said, you know, those words in that Rule 4.03 either mean something or they don't. And the Tennessee Supreme Court said, we believe they do have meaning and have required people to comply with that. Otherwise, the default judgment is to be set aside. And that's what we're asking for in this case. Now, we also raised the question of why didn't they identify the person who was served, as is also required by Rule 4.03? And that was not done in the 2018 case. And there's nothing in the file as far as the 2017 delinquent tax case for that.
You have your time for rebuttal. Thank you. Here from the appellees.
Please, I would like to reserve 4 minutes for counsel for the party that purchased the property at the tax sale.
All right, so you'll take 11, and the council will take 4. All right, 11 minutes, please.
Your Honor, you know, I'm really a little bit tired of counsel arguing that these documents are not in the file. He's argued that throughout the case. I have shown the court numerous times that these documents are in the file. However, he persists in making that argument. It's just flat out not true. He says these documents are not in the court file. They are in the court file. They got mixed up mainly by him. When we stipulated some exhibits, I told him that he had them mixed up by phone. He nonetheless persisted in filing them his way and arguing that they're not there. They are there. I put it in my brief numerous times. We have complied with the rule. He cites Rule 4.031, which has to do with personal service of process. That's not what's involved in this case. We don't have to identify who we serve. If we send, just imagine, if we send certified mail to somebody and they sign it and we get it back, how are we going to know who signed it? If the law is going to require us to identify who signs for the mail, then we have to go out and deliver it ourselves. We can't comply with what he is arguing if we do it by certified mail. If you serve by personal service of process, you can do that. That's Rule 4.031. That's what he's arguing. 4.031 doesn't apply when you're serving by mail. Secondly, this case is not about personal jurisdiction, about service of process. This case is about due process. It's about notice. The cases are replete. The United States Supreme Court has said over and over and over, all they require in these cases is notice, reasonably believed to provide notice. We're not talking about in personam jurisdiction, service of process. Those issues are very, very similar, related. But if you get caught up in that universe, you miss the point. The point here is not about service of process. The point is about providing notice under the due process clause. And the cases have said, the United States Supreme Court cases and the Tennessee cases have said that you can do that by mail. You don't even have to do it by certified mail. You can do it by mail. There are Dusenberry versus United States, citing Mennonite, a United States case, says normal mail is adequate. Wilson versus Blount County, Supreme Court of Tennessee, says regular mail is satisfactory. Davidson Paps versus Worship, 2015 Court of Appeals case cites Mennonite and Wilson and says that's adequate. And Mullane, which is the biggest case here, Mullane says that we don't want to get in the weeds about in rem and in personam. Forget all that. That's what Mullane says. That's what you need to realize. This case is not about that in personam jurisdiction. It's about providing notice. And we did that. It's in my brief. We complied with the rules of civil procedure, even though we don't have to. The rules for tax collection very clearly say that we don't have to comply with the rules of procedure. We comply with the statutory scheme set up for providing notice in tax delinquent cases. That's 2502. It says, we follow the rules of civil procedure except when they are modified by state statute. State statute says all you got to do is send it out, and anybody that's authorized to sign for mail can receive the notice. We don't even have to send certified mail, but we did. And somebody at the office signed for it. During the trial, counsel argues that we're limited to the record. I don't have a problem with that. We win either way. But he's the one that wanted to go forward with the trial and evidence. The judge asked him, and he said he wanted to go forward. So we put on evidence. We have shown evidence in this case. Your Honor, again, you can get in the weeds on this case. Counsel made the point that about the 2016 case, the 2017 case, the 2018 case. Your Honor, this case, we have filed suit against these people numerous times, going back to 2005. And they'll come in at the last minute and pay. We don't have to file suit every time we file suit. That doesn't mean we have to serve them adequately every time. We admit that there's some problems with 2016, 2017. We didn't go forward with those cases. We waited until 2018. And the statute says when we consolidate all these cases, which we did, the statute says that everything is merged into that last case, the 2018 case. And in that case is when we sent out certified mail to the resident, listed the address given pursuant to statute by the property owner in the tax assessor's office. The statute requires them to give a name and address for the property owner. That's where we've sent their notices for 20 years. The party testified that she knew that's where her notices were going. That's where we sent it, and somebody signed for it. That's all we have to do, and that's what we did in the 2018 case. We don't have to do all that for the 2016 case and the 2017 case. We didn't proceed in those cases. We proceeded in 2000, well, it was actually later, but we were going for the 2018 taxes in all years prior to that, which included 16 and 17. So what happened in 16 and 17 is irrelevant.
Excuse me for interrupting, counsel. So the 2018 tax suit incorporated by reference delinquent real property taxes for 16 and 17?
Yes.
So those pleadings incorporated allegations with respect to 16, 17, and 18 delinquent taxes?
Yes.
Okay,
And
thank
the
you.
statute provides for consolidation. We did file suit for 16, and when we filed suit for 16, it went back 10 years. When we filed suit for 17, it went back 10 years. When we filed suit for 18, it went back 10 years. And then we made a motion to consolidate all the pending cases which were granted. And there's an order in the file, which I cite in my brief, showing the consolidation of all those cases. And the statute says that allows for consolidation. The statute says that once you consolidate that, everything is in that one case. That's all you deal with. And we had adequate service of process in that case. Again, Your Honor, counsel made the point that there's no affidavit in the 2018 case. There very clearly is. It got attached to the wrong complaint and service of process somewhere in this trial. And I explained in my brief where all the proper documents are. They are in the court file. It's there. For counsel to say it's not there, it's just not true. Again, Your Honor, I believe that's all I have.
Thank you. Hear from you.
Morning, Your Honors. My name is Paul Krogh. I'm here from the Nashville Bar on behalf of the tax sale purchaser DH Re-10 1 LLC. May it please the court, without disagreeing with anything my friend Mr. Street has said, I think the court can resolve this case on the straightest path to affirmance by looking at 4 pages in the record and considering one fact. And the first page is page 27, which is the return for the 2016 tax sale case, which includes the green card signed by an acknowledged employee of the taxpayer's husband's business, people who routinely signed for her mail over a course of many years, and she knew it was happening. The second page is page 998 of the record, volume 7. That's where the trial court found, as a matter of fact, that certified mail mailing was actually received and service was effected upon that employee on the dates reflected on the cards in that return. We turn from there to page 437, which both of my colleagues have referred to. That's the consolidation order. And the consolidation order ropes this 2016 case, and it's got a 2018 docket number, 2016 tax sale case, into the subsequently filed case. And if we recall what we know about consolidation, that case continues to live on as its own case under the new caption. And so we jump forward to October of 2020, Exhibit 12 from the hearing, and that's the default judgment order. And when it was entered, there was the consolidation order in the record. There was this return from August of 2019, and the trial court entered a default judgment authorizing the sale of the property on that day in both the 2016 case and the subsequent cases. So we have all of the ingredients right there for the 2016 case. We've got service of process, we've got the consolidation, and we have a judgment. And we know that that's good enough because we have this testimony in the record, it's really not contradicted, that the taxpayer allowed over the course of many years the employees of her husband's business to receive her mail related to this property, and she knew it was happening. And it's exactly like the set of facts that the South Carolina Supreme Court addressed in Johnson versus Arbabi, which is discussed in our brief. And because we've got actual implicit authorization there, the court can skip the more complicated question of exactly how far does the presumption in Section 2502 go. We don't have to go there. You've got actual implicit authorization under the facts. There's reference made to a case that I've always called Numbers, Inc. And Numbers, Inc. dealt with a complete lack of proof of service. That wasn't a case about when was it proved or was there a return filed. In that case, there was no evidence that service had ever been effected. Here, the trial court found, based on evidence, that service had been effected. And whether the court ultimately concludes that service was valid in all 3 cases or not, the record clearly supports the trial court's finding as a factual matter that service was good in the 2016 case in which a judgment was entered pursuant to the consolidation order. Absent any questions, my time has expired, and I will thank the court for its time.
Thank you. We'll hear from the appellant in rebuttal.
First, I want to respond to the allegation that I'm referring to documents that are in the court file that I say aren't in the court file. Exhibits, you'll find that exhibits 1, 2, 3, 4, 5, and 6 are all the summonses that I refer to. They are all certified copies from the clerk's office, and they were introduced and accepted by the trial court. They are certified copies. They reflect what was in the court file. And there's not an affidavit there. There's not an affidavit for 2016 in any of the court files. If there were, they had put it in. And as to Rule 4.031, which was referred to by counsel, 4.031 simply says, it's part of obviously 4.03, and it says that anytime there's service of process, there needs to be identification of the person served and the manner of service. It doesn't say that it's limited only to cases where you personally serve somebody. It's a part of Rule 4.03. As a matter of fact, the second sentence of 4.031 tells us that summonses not served have to be reissued after 90 days. That's not limited only to cases where personal service is involved. What it is Rule 4.03 has certain standards that must be met, and there are additional things that have to be met if you're going to serve by certified mail, which is what they tried to do in this case. Now, they talk about then consolidation. The cases were consolidated, I said that, on April 2nd, 2020. But they were consolidated under TCA, as it refers to, TCA 675-2409. That's what the order refers to. And it says in that statute, in subsection B, consolidation of actions to include more recent delinquent tax cases should not require issuance of service or delivery of additional leading process to interested persons who were served or notified pursuant to the original complaint, in accordance with TCA 675-2415. Since there was not service in compliance with 2016 summonses in accordance with Rule 4.03, it doesn't excuse service in any of the three cases. This property was sold for property taxes for 2016, 2017, 2018, in which summonses were issued to my client, and they weren't properly served. We've raised several issues. My client filed this thing within 1 year of learning of it. She put up the deposit of $220,880 to cover the initial bid and any subsequent property taxes that have accrued. And all of the other issues that we raised on appeal, we're not neglecting today. We just don't have time to address anymore. But if you look at this fundamental issue for service of process and the documentation of the return of service of process, and find that those words, just as the Supreme Court says, those words in Rule 4.03 do mean something. And what they mean is if you don't comply with it, any default judgment will have to be set aside. And that's what we're asking you to do in this case. And based upon that alone, the other issues that we've raised are moot if you find that service of process was insufficient in this case, and therefore the default judgment was void, as we say it is. The trial court ignored these issues and just simply said in one sentence, there's been proper service of process. They did not identify who they claimed to have served in 2018, and we produced the only people who had access to that building at that time, and they said they did not sign that. They said, we don't have to prove who we served. how can we refute whether or not that person is an agent if they don't have to prove who they served?
Thank you. Appreciate counsel's argument on this, and as well as your briefs. Yeah. Y'all have a good day.